Welcome back. So we've talked about the employment relationship, and we've talked about the fact that government regulation applies primarily to employees. But in our system, in the United States, it may be difficult to determine who is an employee and who isn't. We know that most labor and employment laws apply only to employees. So the laws we're going to be talking about in here, the Fair Labor Standards Act, Occupational Safety and Health Act, Title VII Prohibition on Discrimination, the ADA, the ADEA, all of these laws are only applicable to employees, to those workers who are classified as employees. But yet in the United States, we have a bifurcated system wherein we need to hire workers sometimes as employees, and sometimes we hire those workers as independent contractors. And so this is our reality, is that when an employer brings on a worker, it can bring on the worker as having the status of employee, or it can hire the worker as an independent contractor. And if they hire that worker as an independent contractor, then all of the laws relating to employment are probably not going to apply to that worker. So of course this makes it very difficult for employers and employees and the government and society as a whole. And making it even more complicated is that the agreement between the worker and the employer that says I am an employee or I am an independent contractor plays a pretty small role in the determination of whether that worker is an employee or an independent contractor. So the contract, the text of the document between the employer and the employee has very little value in determining whether this person is an employee or not. So how is it that courts and administrative agencies determine who is an employee? Because when you bring a claim under one of these employment laws, the first thing you have to do is prove you are an employee. And if they are able to establish that you're not an employee but an independent contractor, then we're looking at a situation where that employment law, you don't get the benefit of that employment law. So courts use a variety of legal tests to determine who is and who is not an employee. And in this lecture, we're going to look at the most common tests used to determine employee status. There are numerous tests. We're going to be focusing on 3 of them in this class. Now, the question of employee status, of course, is critical to understanding regulation. Employment regulation applies to employees, not to independent contractors. So federal statutes that we're going to cover in here apply only to employees. Things like the National Labor Relations Act, Fair Labor Standards Act, ERISA, the IRS, the Internal Revenue Code, the Family and Medical Leave Act, the FMLA, Social Security Act. All of those are based on employment status, employee status. And if you're not an employee, then all those rules don't really apply to you. So any party that is going to seek relief, meaning you want to make a claim that your employer didn't withhold the money from you as required by the IRS, or the employer didn't pay you minimum wages as required by the Fair Labor Standards Act, or the employer prevented you from joining a union, which is required by the National Labor Relations Act, if I want to bring any of those claims, the first thing I have to do is prove that I am an employee. Because those that are classified as independent contractors fall outside the scope of most state and federal employment statutes. Now, it's made more complicated by the fact that statutory definitions are mostly not useful in determining employee status. Ordinarily, every statute starts with a definitional section that says, who does this apply to? Who is this statute aimed at? But unfortunately, the terminology used in most of the statutes is of very little value. So, for instance, under Title VII, which is our primary prohibition on discrimination in the employment, under Title VII, where they define employee, they say that an employee is an individual employed by an employer. You can see the problem with that, right? We're using a word to define itself. So what does that tell us as to who is an employee, who's not? Well, it doesn't help at all, really, does it? Similarly, the National Labor Relations Act says that an employee is anyone who's not an independent contractor. But then it doesn't define independent contractor. So you're an employee if you're not an independent contractor, but we don't know what that is either. So how do we determine that? And as we mentioned, it doesn't matter usually what the parties call themselves. If you and I execute an agreement and I say I'm an independent contractor and you say you're an employer, well, it could be that in fact I'm an employee and I'm entitled to recovery under any or all of those statutes. The case on this, there's a case involving Microsoft that came out of the 1990s. Now, in the 1990s, it was a time of great technological growth. There was a boom going on in technology. And Microsoft especially. Microsoft, during this time period, was transitioning from a company that made Windows, which was an add-on to DOS, which was the disk operating system that most computers came with. And they were creating their own operating system, a real operating system called Windows 95. And this was a tremendous technological problem that Microsoft wanted to control the entire operating system and not be dependent on some underlying operating system. And so in order to create Windows 95, Microsoft was forced to bring on board many, many more workers, programmers, coders, than worked there previously. However, Microsoft knew that once the code base for Windows 95 was built, they weren't going to need all of these employees. And so they created employment positions, employment in air quotes, for independent contractors. And what Microsoft said is, come to us, work for us on this one project. You're not an employee, you're an independent contractor. But in exchange for that, although there's a lot of things you're going to miss out on, we are going to give you more money. We're going to pay you more. And so the employees, the workers, the independent contractors signed on knowing that they would be making more than most of the employees working for Microsoft, but they weren't employees, they were independent contractors. Which was fine for a while until there was another phenomenon that occurred in the 1990s, was this rapid growth in the stock market and the stock market boom. And Microsoft had a program whereby its employees were given stock options. A stock option is a right to purchase a stock at a certain value at some point in the future. And because stock prices were escalating rapidly, exercise these stock options was making a lot of coders wealthy, millionaires even. And so independent contractors who were making more per hour than the Microsoft employee programmers doing the same job became upset that they didn't have the right to purchase these stock options. They didn't get these stock options. And so they filed a claim saying, look, we are employees. We may call ourselves independent contractors, but we're doing the exact same job as the employees. We're working side by side with the employees. We have Microsoft email accounts. They have Microsoft email accounts. Therefore, we're just employees. And this goes up to the Ninth Circuit out in California, appellate court, and the court agrees. It doesn't matter that the parties negotiated to be independent contractors. It doesn't matter that the parties adopted that position for reasons. Instead, the court focuses on, are they employees? And when they use these legal tests, they determine that in fact they were employees. So proving employee status is vital to any employment claim.